Hello friends, this is B.N. Agarwal, ex-Chief General Manager, Steel Authority of India Limited, Bhilai Steel Plant, Bhilai, Chhattisgarh. Today we will talk about Employees Pension Scheme 1995 as the same has been converted into Employees Pension Scheme 2024 by the EPFO department of the country. Today's talk by me will be only limited to the exempted trust prevalent in the country, which are mostly in the organized sectors. You are aware that EPS 1995, there is no separate act or rules for this. This is the part of the EPF Act 1952, way back in the year 1995, precisely 16th November 1995. A special section has been inserted in EPF Act 1952 known as Section 6A, by which the earlier family pension scheme has been merged into the newly called Employee Pension Scheme 1995. Initially, the range of contribution on EPS 1995 was very low. As per the scheme, 8.33 of the employer salary was required to be contributed to the pension fund on a ceiling wages of 5,000 rupees, which went up to 6,500 rupees sometime in June 2001. And again, the ceiling has been raised to 15,000 rupees per month with effect from 1st of September 2014. The employees, the ex-employees, the pensioners particularly, who have completed 10 years of service in an organization and attained the age of 58 are eligible for pension by Government of India under a specific pension formula. I will not discuss this issue. Now, the scheme which it came, many of the exempted trusts, because many of these trusts are getting the exemption right from the inception, maybe sometime in 1955, 1960 and so on. By virtue of a special section 17(1), the organization have been given exemption under the compliance of strict conditions. I believe there are 31 conditions under para 27AA, capital AA, in Employee Pension Fund 1952 to be followed by the establishment for the purpose of exemption. A question comes, why exemption? It goes without saying that the exempted trust, they are independent from EPFO as far as day-to-day management of the trust is concerned. The whole idea behind giving the exemption is to give a trouble-free and smooth services to the employees and ex-employees as far as withdrawal from Provident Fund is concerned, as far as getting the final payment from the Provident Fund is concerned. So it becomes more employee-friendly and ex-employees friendly. Now, under this background, exemption has been granted. The overall framework of the scheme of 1952 Act remains applicable to all these exempted trusts. All the stringent conditions with regard to reports, compliance, rate of contribution, and all the benefits, because the basic idea of exemption is that the rate and the benefits as provided in EPF Act will not be less favorable to these organizations. Under this background, these exempted trusts are running across the country, following stringent conditions, as I said. Time to time, inspections are also carried out by the EPFO department, charging inspection charges also from this establishment. And there is absolutely no problem so far, so forth. One more thing I would like to tell, that exemption has been granted for Provident Fund, not for Pension Fund. Pension funds, pension calculations, pension entitlements continue to be managed by EPFO organization only. All these exempted trusts are run by a well-defined scheme under the Act and the scheme of the government known as exempted trusts. These trusts are run by both employer and employee representatives. Definite number of employees representatives and employers representatives are running this trust, and pension is managed by the Government of India EPFO organization separately and independently. Employer has no say except to remit the contribution at the rate of 8.33% from the employer share. And since there was a ceiling wages kind of thing in the year 1995, 5,000 rupees per month, that means 8.33 of 5,000 rupees coming to around 400 rupees, 417 rupees per month. Then from 2001, 6,500 rupees, that is 541 rupees per month. And thereafter in the year 2014, from 1st of September 2014 precisely, 15,000 rupees per month, that is 1,250 rupees per month was the contribution to the pension fund being remitted by Provident Fund Department, Provident Fund Trust, I should say, to the EPFO organization under the pension fund. We all are aware that the pension we receive from Government of India EPFO organization, the calculations are based on all our contribution on the ceiling wages of 5,000, 6,500 and 15,000 based on the number of days served by us under this different ceiling wages, so-called pro rata calculation of pension with a bonus of 2 years as per the calculation. So the amount comes to a meager amount of rupees 1,000 per month to 4,000 rupees per month, depending upon your contribution, your pensionable salary during the period. All this detailed calculation I will not be discussing in this talk. Now, what has happened then? Where is the problem? See, generally people talk about the Supreme Court decision on higher wages. My understanding goes that pension on higher wages is not a new concept as if propounded by Honorable Supreme Court. The pension on higher wages is in the rule book, that is EPF Act, EPF scheme and Employee Pension Scheme 1995 as well, which has been possibly inserted sometime in the year 1996. Certain stringent conditions were there, like submitting the joint option under para 26(6), under para 11(3), 11(4) of EPF scheme. So many of the employees, I think most of the employees in exempted organization could not file these joint options. And when a landmark decision came in the year 2016, R.C. Gupta's case, therein also this issue came up, and the benefit was granted in favor of pensioners only. But not only this, sometime in March 2017, Ministry of Labour and Employment gave its approval also for payment of pension on higher wages, but based on interpretation of the department, that is EPFO, sometime in May 2017, all these circulars are available in the website. The benefit of pension on higher wages has been denied to exempted trusts. I don't know why. I am of the view that exempted trusts are nothing but the extension of the Government of India only. They are running this office for and on behalf of Government of India EPFO organization. A special and value-added benefits should have been granted to these pensioners pertaining to exempted trust, but it is other way around. I said that this has converted into employees' Pension Scheme 2024, and why so, I will tell. You know, there were certain decision in 2016 R.C. Gupta case. Against that, department went to Supreme Court. Many of the employees and ex-employees, suffering from those decisions, certain decisions, they also went to Supreme Court, and a batch of cases were taken up together by the Honorable Supreme Court and decided together on 4th of November 2022 by a common order. 4th November 2022 means more than 25 months from now. We are yet to get the decision and the implementation of the Honorable Supreme Court's decision so far. Now, let me tell one thing, that there is no interpretation, there is no assumption, there is no inference drawn by us based on the decision of Honorable Supreme Court in November 2022. It is a loaded, clear-cut, bold, and perhaps a capital-lettered, decision as far as exempted trusts are concerned. Para 37, para 38, para 44, sub-para 2 is very clear, loud and clear as far as exempted trusts are concerned and the pensioners related to this trust are concerned. I will go through one or two lines on this decision. I am inclined to talk on this. Very clearly it has been held by the Honorable Supreme Court that the employees of the unexempted establishments and exempted establishments form a homogeneous group. Employees of an exempted establishment should not be deprived of the benefit of getting option to remain in the pension scheme while drawing salary beyond the ceiling limit. It has been further held by the Honorable Court that if the employees of the exempted establishments are excluded from the pension scheme, it would lead to artificial classification of otherwise same categories of employees, and the pension scheme ought to applies to the employees of the exempted establishments in the same manner as this scheme applies to the employees of the unexempted or regular establishments. You will find that almost in 4 places, in a very clear language, Supreme Court has held, Supreme Court has not opined, Supreme Court has directed that this scheme is applicable. I am telling again, Supreme Court has not held any new ruling about pension on higher wages. It has adopted the scheme of the Government of India on pension on higher wages. Every damn thing has been discussed in the Supreme Court decision, ranging into almost 50 pages. Then what next? What has happened? Supreme Court has told, as far as exercising the options are concerned, there was no cutoff date given in the scheme itself. Hence, the employees and ex-employees should be given additional time, and a time of 4 months was given by the Supreme Court for implementation, which was extended from time to time by EPFO organization, and I believe it has been extended last up to May 2024. I need to check it again. And what has happened in between? The whole intention was to implement the decision. Government at all levels have decided to implement the decision. And why I am talking so? Because if you go through the series of the circulars and instructions and advices given by the EPFO organization from time to time, right from I think November 2022 or December 2022 onwards, are for implementation of the decision. Many of the strict requirements under the law, under the scheme have been done away. What is that? Joint option. Under 26.6, para 26.6, under 11.3 and 11.4 have been done away. How it has been done away? It has not been exactly done away, it has been relaxed. In their FAQ, circulated sometime in December 2023, and also a circular issued in June 2023. It has been mandated by the highest authority, that is EPFO organization headquarters, that no joint option is to be rejected for on account of silly issues like 26(6) ka option has not been given, something like this. So then what is to be done? It has been told that any of the proof like salary slip certified by the employer will do the purpose. Any certificate given by the employer will serve this purpose. Basically, this is the face of the EPFO: social security, financial stability of the pensioners. Now, everything went well. Even a online portal has been given. People have started applying online. All joint options, declarations, certificate from the trustees, everything was over. Sometime, I think in between March 2023 to June 2023, everything has been done. Then came the inspection, because you are to get higher pension. So naturally, the data is required to be validated, inspected, verified and authorized at all levels, and it has been done by the employer, by the department, by the inspection team of EPFO. And sometime in September and October 2023, demand notices started getting issued, because the order of the Supreme Court was like that only, that since we have enjoyed the benefit of excess amount, over and above ceiling wages, we have drawn by way of provident fund balance. So that was required to be paid back to the EPFO department along with the applicable interest at the EPFO notified rate. So demand notices were issued. Many of the employees and ex-employees, more so ex-employees, they have deposited based on their own understanding of the schemes. They deposited, and many of them have got the revised pension payment orders. Some people have got pension also. Many people, I understand, have got arrears of revised pension also. Then what went wrong with the exempted trust? And some of the exempted trusts, not all the exempted trusts, because many of the exempted trusts in the country, even today, they are enjoying, and they should enjoy. They are right in their place. What happened? I don't know. But then the things which is coming on record is two things. One is that there is some problem in exempted trust, internal trust rules. And second is perhaps getting the clearance or clarification from EPFO headquarters. It has been stated that a ceiling wages of 6,500 has been mentioned in the trust rule. So that is coming on the way. I really don't understand. If 6,500 is written in the trust rule, is it a compliance? Is it a compliance or it is a non-compliance? Department should clarify. If some places what has happened, nothing has been written in the trust rule and nothing can be written also. This has all coming out of the decision of the Supreme Court when it has reached finality, pension on higher wages. So if nothing has been written, you will not get the higher pension. If something has been written and rightly written, you will not get the higher pension. Over and above that, it is pending for clarification. I am told in some of the organization, it is pending for more than 1 year. Clarification. Can you believe? A clarification is needed on a law laid down by the apex court of the country. Can you accept this? Irony is that for all this period, these pensioners who are waiting for this pension at the age of 60, 65, 70, that means almost 10 years, they will be subjected to pay the interest at the rate of, today's rate of interest at 0.25%. Now they have forgotten their own conditions granted for exemption of the trust. One such condition, number 10 in 27AA, says that if there is any beneficiary scheme, no formal amendment in the trust rule is needed. That same scheme gets applicable immediately and automatically to the trust and to the pensioners. It has been written in the rule. I don't want to discuss in detail, but possibly in EPS scheme 6A or 16A, somewhere it is written that no pensionary benefit should stop to the pensioners for want of any compliance on the part of employer. And it is so stringent that if the employer has not deposited the requisite amount of pension to the pension fund on account of the pensioner, then also pensionary benefit cannot be stopped. In almost all the trusts, a safeguard provision is available that Employee Pension Fund Act, schemes thereunder and EPS 95 provisions will prevail mutatis mutandis over and above the internal trust rule wherever there is any conflict. It goes without saying. Employees Provident Fund Act has been passed by the highest institution in the country, that is Parliament. Whether in internal trust rules, which is nothing but a bylaws for day-to-day management of the trust, will prevail over Act, whether Act will prevail over Supreme Court, Honorable Supreme Court, is it possible? Where are we going? But then that is what is happening. All the trust workings are subjected to EPFO organization. Every damn thing is subjected to. Now this employees, these ex-employees in particular, pensioners, they are subjected to shuttle from pillar to post to get the justice. And what is that justice? A decent living, nothing more than that. And what is the cost? 10 lakh to 50 lakh will be paying. I was surprised to see some of the news stating that 16,000 revised pension order have been issued across the country out of 17.5 lakh applications. Can you believe? Less than 1% compliance so far in 25 months' time. If this is the going rate, perhaps the generation will go for the total compliance. I don't know how many years. Nobody is talking, everybody is talking that how much will be the outgo because of this. Nobody is talking how much the department will get out of the additional contribution being paid by these pensioners. The point is that if there is a loaded, scheme and rules in the Act about pension on higher wages, if the fact remains there are two landmark judgments of the Honorable Supreme Court, one in 2016 and latest in 2022, we need to follow it, or we need not follow it. We need to follow it, on case-to-case basis, because many of the exempted trusts, they are getting this benefit, and I said that they must get it, they are rightly getting it. There is nobody in the country to answer to these questions. Pensioners are raising their voice in the halls of the government from pillar to post. Nobody is answering as to what is to be done. If we are denied of this benefit, if we have energy, we have resources, we have time, and we have merit, then perhaps we will agitate and escalate the matter further. Or otherwise, we will forget this total, benefit as fait accompli. So to conclude, I wish, hope and pray that wisdom and justice prevails across all the levels known as Karyapalika, Vidhayika and Nyayapalika. Thank you.